Hello and welcome to Take from Caesar. My name is David Merlin. While I'm taking care of business, why don't you observe the names in this caption of this very important case from 1993. My website is takefromcaesar.us. If you were to buy the video flash drive on takefromcaesar.us with my tax seminars on it, you'll see that there's nobody else out there that can speak on the level on which I speak as it relates to the tax code. I graduated from the anti-tax movement in 1992 by turning my back on it and never looked back. And it was then that I began to learn things. It wasn't until I started ignoring everybody else out there and did my own research that I finally came to understand the tax code. And I hope you've seen the other videos here on Take from Caesar on YouTube, and hope you've enjoyed them. Hope you learned something from them. That's most important. I'm glad to bring those to you. This is the case of Tyler versus Carter, 151 FRD 532nd. FRD stands for Federal Rules Decisions. It's a different directory from the Federal Second, Federal Third, Federal Supplement, Supreme Court Reporter, so forth. This is a decision about the court rules. United States District Court, Southern District of New York, Terry Smith Tyler, Plaintiff, versus James Carter. He was president. Bill Clinton, president. Ross Perot, American Cyanamid, Iron Mountain Security Corporation, Defense Intelligence Agency, IBM, David Rockefeller, Rockefeller Fund, BCCI, and NASA defendants. This is a civil suit brought in U.S. District Court by Terry Smith Tyler. And I have the cases that I have for a reason. This one stands out in a very particular way that you'll discover when we get into it. Plaintiff brought an action against the president, the former president, federal agencies, private corporations, and private individuals, alleging that they were engaged in a conspiracy to reinstitute slavery and oppress political dissidents. Some defendants moved to dismiss. The district court, Haight, the judge, held that claims describing fantastic or delusional scenarios could be dismissed as frivolous sua sponte, even though the plaintiff was not proceeding in forma pauperis, ordered accordingly. Sua sponte means the court's going to do it itself. It's not going to wait for somebody else to dismiss the case. This is so fantastic and delusional that the court is going to do it, and you'll see the court reasons that I got to dismiss this case even though all of the defendants have not moved to dismiss. I'm going to dismiss the whole thing for all the defendants right here on the court's own motion. Second paragraph. Claims describing fantastic or delusional scenarios are subject to sua sponte dismissal as frivolous, even though plaintiff asserting claims is not proceeding in forma pauperis, but rather has paid the filing fee. So Terry Smith Tyler, she paid the filing fee, and he's going to dismiss it anyway. District Court would, sua sponte, dismiss as frivolous plaintiff's claims against federal agencies, president and former president, private corporations, and private individuals alleging conspiracy to reinstitutionalize slavery and oppress political dissidents. Claims describe fantastic or delusional scenarios. Terry Smith Tyler, pro se. Mary Jo White, attorney, Southern District of New York, for the defendants President Clinton, Defense Intelligence Agency, National Aeronautics and Space Administration, William J. Hoffman, U.S. Attorney, New York City, for the United States. Memorandum opinion and order from Mr. Haight, district judge. This case is before the court on a motion to dismiss by defendants President Clinton and Defense Intelligence Agency and National Aeronautics and Space Administration, hereinafter the federal defendants. Plaintiff has also filed an order to show cause why the World Trade Center bombing trial should not be enjoined. For the reasons set forth below, plaintiff's order to show cause is denied and the clerk of the court is directed to dismiss the complaint. Background. This is where we step into deep, deep space. Plaintiff Terry Smith Tyler, appearing pro se, filed a complaint in December of '92 alleging a bizarre conspiracy involving the defendants to enslave and oppress certain segments of our society. Plaintiff contends she is a cyborg and that she received most of the information which forms the basis for her complaint through Proteus, which I read to be some silent telepathic form of communication. She asserts that the defendants are involved in the Iron Mountain Plan, which provides for the reinstitutionalization of slavery and blood sports, which she identifies as death hunting and witch hunting, see footnote number 1, and the oppression of political dissidents, herself included. Footnote number 1. Death hunting is described by plaintiff as follows, quote, in death hunting, teams of pimps and harriers, women working for the pimps, follow a black woman they want to force into sexual slavery and snuff rackets, try to wreck her employment prospects, isolate her socially, break up with her friends and family. Often they try to force her into welfare because it often circumscribes her choice of places to live. Sometimes members of a woman's family or her mate will be cooperative or part of death hunting teams because participants get paid, end quote. Plaintiff asked the court to grant her the following relief. Number 1, $5.6 billion in compensatory and punitive damages. 2, a physical accounting of all black women born since 1940, including their present whereabouts, and for those who have died, and an investigation into how they died. Number 3, the purchase of land in Africa for the immigration of abused black women. Number 4, the bringing to justice of those responsible for the American Holocaust. Number 5, an investigation into the foster care system and a physical accounting of all black children placed into foster care. Number 6, an end to slavery in the United States. Number 7, the end of the cyborg program run by NASA, the Defense Intelligence Agency, American Cyanomet, and IBM. And number 8, an end to the organ donor program. Bottom of the paragraph just above that, before we go to the next page, plaintiff's complaint alleges a number of personal indignities visited upon her by the defendants. Quote, strafing of my dormitory room by planes and helicopters, the electronic bugging of my student rooms and apartments, deliberate noise harassment, blasting of loud rock music with lyrics designed for witch hunts, music about social pariahs, students following me around to prevent me from studying, whispering campaigns, and social ostracification. Plaintiff also makes the following allegations against the defendants. Former President Jimmy Carter was the secret head of the Ku Klux Klan. Bill Clinton is the biological son of Jimmy Carter. President Clinton and Ross Perot have made fortunes in the death hunting industry and are responsible for the murder of at least 10 million black women in concentration camps, their bodies sold for meat and their skin turned into leather products. The defendants are also responsible for breeding farms, which turn out 2,000 black girls a year who are then sold for recreational murder or as human pets. Additionally, the defendants utilize weather control and earthquake technology to threaten other countries that object to the Iron Mountain Plan. While plaintiff was trying to effect proper service of the summons and complaint on the defendants, she made a number of appeals to the court for interim relief in the form of orders to show cause. On January 20, 1993, she asked the court to enjoin the inauguration of President Clinton. The court denied her request as moot. In August 1993, she moved to enjoin the installation of Louis Freeh as director of the FBI on the ground that Clinton appointed Freeh only so Freeh could cover up evidence of Clinton's wrongdoing. That motion was denied as it lacked a sufficient evidentiary basis. Presently before the court is an order to show cause why the court should not enjoin the trial of the World Trade Center bombing case, now proceeding in this court before Judge Duffy. Plaintiff alleges that President Clinton ordered the bombing of the World Trade Center in order to justify war with Iraq. In support of her application, plaintiff describes certain Proteus communications she had with other individuals. Plaintiff alleges that the United States invaded Panama and arrested General Noriega because Noriega objected to the United States soldiers raiding Indian tribes in Central America for child sex slaves to torture in American cocaine-based thrill-killing rackets. Plaintiff contends she wrote to Noriega asking him to join in her lawsuit, but that United States soldiers holding Noriega beat him when he asked for his mail. Plaintiff asserts that in 1988, Rajiv Gandhi spoke to her through Proteus and informed her that he was being held prisoner and sexually abused by a man whom he had caught stealing from the funds generated by the Bhopal disaster settlement. According to plaintiff, Yasser Arafat tried to confirm Gandhi's tale of abuse on behalf of the plaintiff, to no avail. Plaintiff additionally contends that Gulf War against Iraq was undertaken so that America could restock its sexual slavery camps, which had been depleted. According to plaintiff, 40,000 Iraqi soldiers captured by the United States, selected for their physical attractiveness, have been brought to this country where they were, quote, being beaten, forced to run gauntlets, and homosexually gang raped by American soldiers, end quote. Plaintiff claims to have confronted Secretary of Defense Cheney with evidence of this allegation. Cheney, through Proteus, purportedly told the plaintiff, quote, well, we were so sick and tired of killing black girls. We just had to put some variety back into our death-hunting industry. And they, the Persians, are incredibly beautiful. The beauty of the face heightens the pleasure of the kill. I know no higher pleasure than the gang rape of exceedingly beautiful people. End quote. Additionally, plaintiff alleges that the Serbian government, the Nazi Bund, the Bank of Commerce and Credit International are also involved in the conspiracy. Attached to plaintiff's papers and apparently offered to support her claim are a number of exhibits. Most prominent among the exhibits is a book by Robert Ellis Smith entitled Privacy, How to Protect What's Left of It, 1979, and a four-page illustrated pamphlet advertising pornographic movies starring young men. Plaintiff has circled a number of photos of naked men who appear to be of Mediterranean or Latin American descent, which I interpret as her evidence that Iraqi and Central American men are enslaved in pornographic rackets. Plaintiff appears to have effected service on a few of the named defendants, although IBM and BCCI each made an appearance and successfully moved to have the claims against them dismissed. Plaintiff never filed proof of service against either defendant pursuant to Federal Rule Civil Procedure Number 4G. Service was eventually made against the federal defendants, but it may have been effected more than 120 days after filing. What a shame. IBM's motion to dismiss the complaint against it was granted by order dated September 29, 93. That same order dismissed the claims against BCCI to the extent they could be asserted against the superintendent who was supervising the dissolution of BCCI. Currently pending before the court is a motion to dismiss by the remaining defendants and the order to show cause to enjoin the World Trade Center bombing trial. Discussion. In Nitschke v. Williams, a state prisoner commenced a federal action by filing a motion to proceed in forma pauperis and a complaint under 42 U.S.C. 1983 charging prison officials with violating his constitutional rights. The in forma pauperis statute, 28 U.S.C. 1915d, authorizes the courts to dismiss an in forma pauperis claim if the action is frivolous. The district court dismissed the complaint sua sponte as frivolous under 1915d on the ground that it failed to state a claim upon which relief could be granted under Rule 12b-6 of the Federal Rules of Civil Procedure. The Seventh Circuit reversed. The Supreme Court affirmed the Court of Appeals. It held that a complaint filed in forma pauperis is not automatically frivolous within the meaning of 1915d because it fails to state a claim. The court in Nitschke contrasted the judicial screening process available under the in forma pauperis statute with cases where the plaintiff pays the filing fees. Section 1915d screening reflects, the court stated, congressional recognition that a litigant whose filing fees and court costs are assumed by the public, unlike a paying litigant, lacks an economic incentive to refrain from filing frivolous, malicious, or repetitive lawsuits. A complaint filed by a fee-paying litigant subject to economic incentives can be dismissed under Rule 12b-6, but in such a case, the court stated, Rule 12b-6 does not countenance dismissal based on a judge's disbelief of a complaint's factual allegations. District judges looking to dismiss claims on such grounds must look elsewhere for their legal support. But the court left open the question whether a district judge could ever dismiss a complaint sua sponte under 12b-6. Quote, we have no occasion to pass judgment, however, on the permissible scope, if any, of sua sponte dismissal under Rule 12b-6. Number 1. Among the factual claims subject to 1915 dismissal as frivolous are claims describing fantastic or delusional scenarios, claims with which federal district judges are all too familiar. The claims of plaintiff at bar may be so characterized. The question is whether such claims asserted by a fee-paying plaintiff are subject to sua sponte dismissal by a district court under Rule 12b-6. I hold that they are. Remember, this is a federal rules decision case. This is about the rule. It's not about the merits. It's not about standing. It's not about proper service. It's about whether or not, under a certain rule that allows dismissal of cases, can I just get rid of this, get it out of my court? It's so wild and crazy, fantastic and delusional, I should be able to just deep six it. A plaintiff asserting fantastic or delusional claims should not, by paying a filing fee, obtain a license to consume limited judicial resources and put defendants to effort and expense. The policies arguing against sua sponte Rule 12b-6 dismissals do not apply in these circumstances. The author of claims as irrational as these cannot be regarded as subject to the economic incentive to refrain from frivolous actions imposed by filing fees and court costs upon rational paying litigants. Similarly, a sua sponte dismissal of a complaint such as this cannot reasonably be said to deprive such a plaintiff of the opportunity of clarifying his factual allegations so as to conform with the requirements of a valid legal cause of action. If this court cannot order sua sponte dismissal of this complaint under 12b-6, no district court can ever dismiss sua sponte any complaint under the rule. Meaning, if I can't dismiss this one, nobody could ever dismiss one. This is the pinnacle. Number 2, the clerk of the court is directed to dismiss the complaint as to all the defendants with prejudice and without costs. The clerk is directed to refund to plaintiff her filing fee. Plaintiff's motion by order to show cause to enjoin the World Trade Center bombing trial is hereby denied. It is so ordered. Sayonara, Terry Smith Tyler. Or was it Terry Tyler Smith? Terry Smith Tyler, plaintiff. So now we know what frivolous is. If a judge ever calls you frivolous, just say, excuse me, but that's frivolous. I'm just confused. Anyway, thanks for letting me share that with you. And we'll see you in the next lesson.